Today's session is construction phase risk management, and this really is when the owner starts to actually put a project into the ground. Up till this point, you have helped the owner through the design phase. You have hopefully helped them through the bidding and negotiation phase. But at this point, you and the owner and the contractor will start thinking and working on the construction of this project. And what we'll be talking about in this presentation are your roles and responsibilities, responsibility for construction site safety, submittal, observations and evaluations, change orders, and certification. So let's get started. It's important to realize what your roles and responsibilities are. And in this presentation, we are assuming that you are in a design, bid, build environment. So let's review exactly what the contractual relationships look like. The owner has the program and the site. They have particular requirements that they want implemented, and they have control of a construction site on which they want to put in a particular facility of some sort. And so that's what the owner wants. And to have that developed, they have engaged you, the design firm, to develop contract documents. And this means that you as a design firm have designed the construction, the facility that's going to be constructed, and have presented it to the owner. Now the owner puts that design solution into the contract documents and presents it to the contractor. And at that point, when they have a contract with the contractor, between the owner and the contractor, that's what the relationship, that's what governs the relationship between the owner and the contractor. One thing that we have to realize is that when the owner presents that information to the contractor, there's something called the Spearman Doctrine that comes into play. And that actually comes from a 1918 United States Supreme Court decision. Generally speaking, what that doctrine says is that when the owner provides these construction documents to the contractor, there's an implied warranty that goes along with that. And the implied warranty that the owner presents the contractor is that the information, plans, and specs which the owner is providing the contractor is sufficient for the contractor to construct the facility. If for some reason there isn't enough information or there's ambiguity in those documents, then that is really the responsibility of the owner, and the contractor is not going to be expected to eat the cost for a deficiency in the documents. Note that, as we've discussed in other sessions, you as a design firm aren't providing the owner with that kind of implied warranty. Generally speaking, you are expected to perform services in a manner that meets the standard of care. So as long as you've met that, you are not responsible to the owner to provide them with an implied warranty. But the owner actually does provide the contractor with an implied warranty to that the information is sufficient. So that is indeed a big risk that the owner has. So if, for example, there are unforeseen site conditions or there's something in the site that was not discoverable until construction starts, that risk really falls on the owner. The owner also is responsible to pay to the contractor and the design firm, but really now that we're talking about the construction, to pay for the construction that is happening. And that is part of the responsibilities that the owner has that needs to be completed. So that's the owner's responsibility. Now, your role as a design firm in a design bid build environment is to actually administer the contract for construction, right? It is, you are not there to do construction administration. What you're administering is the contract for construction. So it's very clear that your responsibility remains as that of a limited agent for the owner in the administration of this contract. You, in your desire to solve problems for the owner, should really avoid taking actions that are specified as the contractor's responsibility under the contract documents. This is where oftentimes, especially if you're dealing with an owner who doesn't have much experience with construction, the owner may expect you to take on roles that are typically the responsibility of the contractor, and that could open you up to claims and challenges simply because that is really not your role. So let's talk about what the contractor's responsibilities are. So at the moment that construction begins, the contractor is responsible for the construction site. What does that mean? Well, the owner typically then turns over the site to the contractor, and the contractor has to control the site. They have to make sure that it is safe, that the means of egress and access are controlled. So if there's fencing that's required to prevent members of the public from accessing a live construction site, that is the contractor's responsibility. This responsibility stays with the contractor typically until substantial completion of the project. So that is a major part of the contractor's responsibility to maintain control of the construction site. That also means that they have a responsibility even before construction starts to visit the site, check the plans, and inform themselves of the requirements of the work, because ultimately what the contractor is responsible for are the construction means, methods, techniques, sequences, and procedures, and we'll talk about that. But this is an important distinction that has to be clarified as you understand what your role is in the construction contract administration place. This is a phrase that is well known in the industry, that means and methods, generally speaking, are the responsibility of the contractor. Anytime I do this presentation on construction phase responsibilities, the topic of responsibility for safety comes up. And really, again, safety is generally the responsibility of the contractor, and it usually lies just with the contractor. Unless you as a firm are providing fairly specialized services on a mega project where you're taking on responsibility for safety as a specialized service and you're reviewing safety plans and providing that kind of specialized service, which can be done. It's a specialized service. In a typical role, the design firm does not have any responsibility for site safety. That is typically the contractor's responsibility. The other responsibility that the contractor has is to develop the schedule of values, and we'll talk about that when we are talking about your responsibility for pay applications, which generally goes off of the schedule of values that the contractor has provided to the owner. And then also the contractor is also responsible for creating and submitting construction schedules and a schedule for submittal. So all of these responsibilities lie with the contractor. So having said something about construction site safety, let's start in on that topic. This is a big topic because obviously whenever there's an incident on a construction site, you as the architect or the engineer may be pulled into allegations that really you are somehow responsible for this. So it's important to be aware of what your responsibilities generally are and some of the key things that you can do to help manage your risks in the event that you are pulled into one of these situations. So as we said, the contractor is generally solely responsible for safety on the job site. And really, the reason for this is that the control element that I mentioned earlier. When construction begins, the owner formally relinquishes control over the site, and it is the contractor's responsibility to secure the site, control the access points, and maintain it in a safe manner. That is why it generally doesn't make sense for a design firm to assume any kind of responsibility for safety on a job site because simply you do not have any control over the construction site, nor do you have any control over the personnel that may be working on the job site. So without control, it really does not make sense to have any kind of responsibility for safety. In some situations, though, the courts have said you as a design professional may have some responsibility if the following factors are in place. If the risk of injury is foreseeable, and so the easiest way really to illustrate this is by way of example. If, for example, you are at a construction site and there is a trench being dug and you know, based on the knowledge that you have, that there needs to be a trench box in place, and there isn't one, and there are workers in that trench, then the risk of injury is foreseeable because of a sudden caving event, right? So you have, in that sense, you may have some element of control. You may be able to notify the superintendent that indeed you think that there is a trench box that is required at that time and place. And you, as a design professional, actually have actual knowledge of that requirement. It is pretty common that indeed, if there's an excavation that is deeper than a certain number of feet, that you need a trench box. And then finally, you need to have a reasonable opportunity to avert the harm, meaning you need to be able to look at the site, look at the condition, and inform somebody about the dangerous condition. And if all of these elements are in place, and there is indeed an accident, an incident, then you may be held responsible. So as a design professional on site, you need to be aware of exactly what it is that you're looking at, and be aware that if you see something that you know to be dangerous, that you indeed have an affirmative duty to say something, do something, inform someone about the unsafe condition that you have seen. It's not really something that you want to pretend like you haven't seen and hope that nothing happens. You do have an obligation to say something if you see something that is unsafe. You, as an individual, would also like to be able to help out somebody. If you know something is dangerous, I think it's very human to say, hey, that's dangerous, move. If you think it's imminent danger, I think the human impulse on your part should be to say, hey, this is indeed dangerous. You don't want to be in a continually defensive posture, thinking that if you don't say anything, nothing's going to happen. The reality of it is that it is, if you are on site and there is something dangerous going on, in all likelihood, you will be included in any allegation that relates to an accident. What oftentimes does save you, though, is your ability to show what it is that you did, what kind of actions that you take, and we'll talk about that in the next slide, and be able to provide yourself with a defense in response to the allegations. So if you see an unsafe condition, you should report it to the construction superintendent, inform the owner about what it is that you've seen. In specific cases, you may have a duty to report it to the appropriate regulatory officials. That's a case-by-case determination on your part. And if danger is imminent, if something is truly about to happen, if the trench, for example, that I mentioned earlier is indeed starting to cave in and you see that, I think it makes sense for you at that point to do what any other reasonable person would under the circumstances. It would be to say something to the workers. Hey, move, get out. That's dangerous. You're in danger. That is, I think, what would be the prudent way to react if you see an unsafe condition. And it's not to say that this is an everyday occurrence, but I think all design professionals who are on site wearing a brand new or shiny hard hat, contractors generally know who is, on a day-to-day basis on a construction site and who is not, just depending on how shiny your hard hat is. So you really need to know what your responsibilities are in the event of an unsafe job site condition. So hopefully that addresses your concerns or your scope of responsibility if you are on a job site. And this is always a topic that generates a lot of questions from design professionals when we talk about construction contract administration responsibilities. So let's now talk about the issue of submittals. And submittals really fall into various categories, but you should think of submittals, which we'll talk about, in the same line as RFIs, a request for information. A request for information is really the opportunity for the contractor to ask for information, to ask questions about the drawings, about the spec sections, whatever it is that they need clarification on. And then they're really risk management tools. It lets you know what the contractor is seeing and what they're thinking. And there usually is a procedure manual that identifies what exactly the process should be for how RFIs are submitted to you. So before we get into submittals, you should be aware of what that what the requirements are. And if you start getting RFIs, establish and enforce clear RFI procedures so that it is clear what the contractor's responsibilities are. And as we'll talk more about this, really, in a construction contract administration relationship between you and the contractor, there isn't a contractual relationship. Your contract is with the owner. However, setting expectations about what is reasonable from the contractor starts from the beginning, and if you establish that correctly, then the relationship can be is set on the right track, and there's a greater chance that the construction project will proceed smoothly. So always, when you're getting requests for information, require specificity from the contractor so that it is clear what it is that they're asking questions about. It's not your job really to read the documents for the contractor. That's their responsibility. They need to take ownership of what is in the contract documents and build a facility. But if they have questions, you ask them to provide them to you in a request for information. Now, submittals are different. They are communication tools. This is how the contractor is telling you what they intend to do about the construction. How do they intend to build this thing? And your role is to review the submittals, the shop drawings, to see that they are indeed consistent with the design concept that is expressed in the drawings. So the first thing you want to do, especially on a large project, is to ask as a preliminary matter and make sure that the contract documents requirements that they have a schedule for submittal, especially for large projects, because that schedule tells you exactly how much thought the contractor has put into the submittal process, what it takes to get it approved. Then once the submittals are approved, oftentimes that kicks off fabrication for specialized equipment that is specific to the construction site, but until your shop drawings are approved, that doesn't start. So it needs to be really coordinated with the construction schedule, and after you've approved it, or when you're reviewing it, the contractor should budget into their schedule time needed for review, and oftentimes time needed to provide resubmittal. So that is indeed a way to make sure that the contractor is really thinking about planning the project properly. So the shop drawings show the construction means and methods that are not typically found in the construction documents. And they are communication tools. In the standard form documents, in the EJCDC and AIA documents, it's very clear that shop drawings are not contract documents. This is a communication tool that comes in from the contractor to you so that you can review what they intend to do as far as construction is concerned, because they are responsible for the means and methods, and you are reviewing that shop drawing to make sure that it does indeed meet the concept as the design concept that is expressed in the construction document. Now, as you all know, there are certain situations when you do delegate design responsibility to the contractor. And this is typically done for a specialty scope of the work, right? So if there's something that is specialized that does require a particular solution, the contractor's responsibility is to engage typically another design professional, a licensed design professional, and prepare a particular solution and submit that to you, the design firm, for review. You, in that case, if it is indeed a delegated design responsibility, you are responsible for specifying all of the performance or design criteria that must be satisfied. And you're still responsible for reviewing and approving the contractor's submittal for conformance with the design concept. Just because they have engaged or are required to engage a licensed design professional does not mean that you are not still responsible for reviewing the submittal to make sure that it conforms with the concept, the design concept that you have shown in the drawing. So shop drawing review indeed needs to be planned for. It does take time for you to do a proper review, especially if it's a fairly complex facility, and really adequate time needs to be budgeted for on your part to do that. So what is the contractor responsible for? Well, they are responsible for reviewing, coordinating shop drawings produced by subcontractors or suppliers, meaning that you as a design firm should never accept a shop drawing directly from one of their subs. It's the contractor's responsibility to review all of the shop drawings that come from their subs and approve it and submit it to you, so that it's very clear that the general contractor is taking ownership for what is being proposed. To that end, you want them to approve, to put an approval stamp on them before they submit them to you for review. So once you get that, you are then comparing the information in the shop drawings to the information and design concept in the contract document. Typically, you note any deviances and inform the contractor, and you should only review and approve the aspects for which you are responsible. So if you're receiving shop drawings that don't relate to something that you have asked for, that isn't a requirement, you return it back to the contractor and say, hey, contractor, this is not what was asked for. We're not reviewing this. We're sending it back without our review. So, for example, if your contractor submits to you their safety plan, then they want to send it to you and they ask for you to review it, unless that is something that has been asked for and you're providing that particular service, you certainly don't want to be doing that type of review because it's not your responsibility, and it may be an attempt by the contractor to kind of spread their responsibility around. So by your actions, you don't want to be caught in the position of having reviewed documents that weren't part of their contract. And then you place a review stamp on it and return to the contractor. And we'll talk about submittal stamps in a second. So what should you be looking for? You need a summary list of submittals. What is it that you should be expecting from the contractor? That's typically stated in the contract documents. You should be looking at the submittal and progress schedules. The construction schedules are coordinated so that it is clear that as they provide you with schedule updates, that they've thought about what the submittal requirements are and how that impacts their progress. And then, of course, each party should know and timely fulfill its contractual obligations. That your submittal stamp, we'll talk about this in the next slide, reflects your contractual obligations. And that finally, you have a submittal log that reflects as planned and actual receipt and return dates and actions taken. So that if there's something that comes up later about the amount of time that it took for you to review shop drawings, you need to be able to go back to your log and actually show what it is that you provided to the contractor and how that compared to your contractual obligations and so on. So that submittal log can be very important. Finally, your submittal stamp really needs to reflect what it is that you're doing the review for. And as long as that's clearly stated in the stamp, our guidance is that that is really what controls. Some design professionals are leery about saying approved, rejected, or so on. But to date, we really haven't seen any cases that have depended on, that have implied that using the word approved means that you're taking on responsibility for construction means and methods. If you're uncomfortable in your own practice of using the word approved, rejected, and so on, as shown in that stamp, you can certainly use the language on the left that says no exception taken, and so on. But what we think really makes sense is to make sure to review the actual verbiage in the shop drawing to make sure that it does indeed state that the contractor is ultimately responsible for construction means and methods, and that you're only checking for conformance with the design concept as expressed in the construction document. All right. So the next phase that you need to be thinking about in the construction phase, construction contract administration that you're providing, are observations and evaluations. And really, what does that mean? Typically, as a design professional, you are asked to be out on site to observe what the construction looks like. You're not, at least as envisioned by the standard form documents, you're not really providing inspections, which implies a detailed review of the actual construction that has occurred and what has been done in terms of quality. You're providing, at least as envisioned in the standard form documents, what are known, characterized as observations or evaluations of the construction that has been put in place. So some of the activities that this could entail are site visits during construction. How often do you show up during critical junctures, critical concrete pours? What is it that you are obligated to be there for, or how often are you going to be there? In some cases, in larger projects, the owner may actually engage you to provide resident project representation, meaning that you will be there on site every day and observing what the contractor is doing. How much workforce do they have on a daily basis? What kind of activities were taken that day by the contractor? And then you also facilitate, shop drawing review, and if you have the authority for it, as you may respond to RFIs and so on. But that could be one of the activities that you provide. Communications and documentation about what is going on, what needs to occur. You may need to document that the erosion control measures, for example, have been put in place, and that the permit requirements are being met. If there is water control issue, quality control issues that need to be in place, that may need to be documented and communicated with the various parties that are involved. There could be a need for programs, inspections, and testing. What is your role in that? Are you engaging, making sure that the people who are doing these inspections are showing up? Special inspections like pipe wells, testing that may be required to make sure that things are being done. That could be part of your activities during the construction phase. You may be asked to provide certifications based on your evaluations. We'll talk about certifications at the end. And then finally, you need to understand that based on these types of services, you may have the authority to reject non-conforming work. And this is a typically huge responsibility. Not all firms have it in their contract. Owners um, may not want you to have that kind of authority, but if you do, you may be called on to reject work that does not conform to the drawings, to the contract documents as you see it. Now, one thing I want to repeat always is that you're not there to supervise or direct the work. Clearly, that's not your responsibility, and you're not there to perform inspections of the work. You're really not. You're not there to provide detailed review of every aspect of the contractor's work. Generally speaking, that's not what you're providing when you're doing this. So let's talk about the authority to reject non-conforming work. Remember that if you indeed decide that something doesn't meet requirements of the contract and you are going to reject this work, you are going to get a response from the contractor, because that is work that has been put in place. If they're being asked to tear out something, remove something, replace it with something that complies, that's an additional cost. So the contractor is certainly going to respond to that in any number of ways. So you need to be able to back up why you made the determination that it does not conform. So check what your scope of responsibility is. If you are a prime, say like an architect, and you have a consultant who's responsible for the HVAC system, your mechanical, make sure that the consultant is indeed involved and is providing you with appropriate guidance. Be aware that ultimately the owner generally has the right to accept non-conforming work, but if it does not meet code requirements, you need to be involved in that. So clearly, if it's something that doesn't meet code and it doesn't ultimately endanger life, health, safety, welfare, or if it's going to get in the way of the owner being able to get a certificate of occupancy, you certainly need to know the owner that there are indeed ramifications to that. And depending on the situation, you may even have to, if the client is insistent on accepting it, you may have to make a determination on what your responsibilities are as it relates to those limitations. But generally speaking, if the owner wants to decide to accept it and there aren't other limitations, they can do that. That's ultimately the owner's facility. When you're rejecting non-conforming work, your rejection should not include corrective advice, because at that point, if you're telling the contractor what the solution should be, then you are indeed owning that particular solution. And if there are issues involved with that, then you could be roped into those claims. So always make sure that that piece of the rejection does not include corrective advice. We have seen cases where that has led into claims that were very difficult to resolve. Finally, obviously, the contractor decides on means and methods, and you, as a design professional, should focus on the result. Finally, one thing I'd like to say is that, if you decide to go out on site, do a site visit, let's say it's Friday afternoon, and you want to knock off from the office early, and you want to stop by the construction site on your way home, that's fine, but your actions should be ideally documented, right? So one thing that we suggest is that after each site visit, you prepare a written report and say, okay, we were on site, this is the activities we saw, these are the things that were going on. Whatever it is, oftentimes there may be a form that your firm has developed. In other words, if you are on site, it's always a good idea, at least from my observation, to document that you were on site, what you saw, and provide it to others, so that if there's any question about what exactly was going on that day when you were on site, then you have some documentation to help provide you with an answer for any questions that may, or issues that may come up. So Construction obviously is a fairly complicated endeavor, and contract changes are not unusual in any large construction project. Change order is a modification of the owner-contractor agreement. What that means is that during construction, something has changed. There may be a need for additional work or a need to remove work. But generally speaking, something has changed and you need to execute a change to the owner-contractor agreement. If the change relates to the construction, typically it requires the signature of the owner, contractor, and design professional, because as the licensed design professional, you often have a responsibility to make sure that the changes make sense and are in compliance with any code requirements and all of that. So, it does require work on your end to make sure that the change order is negotiated accordingly, it's described properly, and that both parties can agree on what the proposed change is. So there are, various ways of handling a contract change. It could be as simple as a minor change or field order. This is something typically that is deemed not to impact the cost of the contractor, not to impact the schedule, and if everybody agrees that is the case, it may be indeed handled by something as just a field order to document exactly what the change is, and if everybody agrees that it's not a major change, it doesn't impact the schedule, then it's not. It can happen fairly quickly. A change order typically, though, means that there is something that has changed, right? It could be an addition. It could be a deletion, meaning that the scope of work that is going to be put in place has been removed, or it could deal with substitutions. And one thing that you should be aware of is that if you are indeed reviewing substitutions and something has been approved, that needs to be reflected in a change order. One thing that you as a design firm should be aware of is that the changes should be reflected in change orders. So if you're reviewing shop drawings, for example, and the contractor is proposing a substitution, the way to affect that, if you agree that that is indeed meets the design concept and makes sense and so on, is number one, you need to make sure that you're being paid for that additional service. And number two is to make sure that there is a formal change order that is indeed executed by all parties to reflect what that changes. You don't want to be in a position of having agreed to a substitution by way of shop drawings only, because shop drawings, as we said earlier, are communication tools. They're not contract documents. So you need to be aware of what the implications are if that is indeed the route in which the contractor is proceeding. Perfectly acceptable if there's going to be a substitution and you think it makes sense based on the review and so on, but make sure that it is reflected in a formal change order to make sure that the contract documents reflect what is going on. And finally, if something is critical or needs to be addressed quickly and you want to direct the owner wants to direct the contractor to do something, you can issue something called a construction directive or a work change directive, whereby the contractor is asked to immediately deploy the forces to do something that could be time sensitive, and you're not actually waiting to negotiate a formal change order. In that case, that will come later. But there are other ways. There is a way to address an immediate requirement by issuing a work change directive from the owner. So when you're doing change orders, who has the authority to order changes? Typically, that's the owner. But as a design firm providing services to the owner, what you want to be thinking about is, okay, that's fine, we've agreed on these changes, but what is the impact of the change or the number of changes? What's the ripple effect on the schedule? Because from the owner's standpoint, it's not just about the changes, but they also want to be able to have control of the facility by a certain milestone. Remember that the construction itself does require resources, and the owner, your client, may have financing obligations, and the clock may be ticking. So attention has to be paid to the progress schedule to make sure that the contractor is not losing time, and if they are, that it is indeed documented and all parties agree what the impact is. And so you insist on schedule updates from the contractor. And then the last thing I want to say about contract changes is that you need to adhere to what the changes clause says. And as an administrator, you need to be perceived as fair and impartial about administering the change order and calling it as it is. It is important that these are resolved in a timely manner, because if it's an unresolved change issue, then that ultimately will become a claim. And oftentimes you're going to be dragged into that. One thing that you need to be aware of as a design firm is that you do, if there are changes, and even if your drawings are missing something, the owner oftentimes would have had to pay for the missing item anyway. So if it had been included in the plan, the owner would have paid for that. So let's say your plans are missing a guardrail, which is required. The owner would have had to pay for the guardrail, right? So what you are responsible for is not the cost of the guardrail, but if the owner has to pay a premium to have the guardrail installed because it was not shown in the original plans, then that premium over and above normal cost could indeed be your responsibility, because there could be a claim of negligence on your part, that you should have included this, didn't meet the standard of care, and therefore this is the harm that the owner suffered. It could be that in your role as the administrator of this construction contract, there could be issues like that may arise, that, oh my God, we didn't show this. That your role in that phase is really not to be defending your design, is to generally call it as it is, be fair and impartial, and oftentimes these things are worked out amicably, and as long as you're honest and upfront about it, then that, I think, helps the favorable resolution of the claim. So the last thing I wanted to talk about are certifications. And this is something that is often called from the design professional to provide a certificate of some sort. Typically, these are progress certificates. For example, what percentage of the work has been put in. This type of certification is used to process pay applications. Completion is a big issue. Substantial completion dates are very important to the owner, and that is a term of art in the industry. It tells somebody is the date by which a stage or designated portion of a construction project is sufficiently complete in accordance with the contract for the owner to occupy and or utilize for its intended use. That's kind of the definition that the standard form documents like the AIA and EJCDC use, so that the owner can start using the facility without undue interference. So from that point on, they can start using the facility. There may be some minor punch list items that you're still resolving, but in terms of the use of the facility, that has been turned over to the owner. So substantial completion dates are important because generally they determine, okay, if it's substantially complete, if there's any retainage being withheld, generally that's the date on which that can be released to the contractor. The warranty period begins. Oftentimes the equipment that's been put in place and so on does have a warranty. Those dates could start running at that point. Also the warranty obligations that the contractor has provided. If there is a delay, the date of substantial completion determines the actual or liquidated damages due to the delay in the project. And also, of course, it means that the statute of limitations and the statute of repose, those start running at that point. So clearly, your certification about when substantial completion happens is indeed an important element of the construction project. And then finally, compliance. Compliance with code. Does the stormwater detention facility comply with the requirements as stated? You may need to have a surveyor out there to tell you what the elevations are and so on. And that could be a certificate that's required for the owner to proceed with the project. So a certificate really is a written assurance that some act has or has not been done, or some event occurred. So it's a statement or some fact in writing signed by the party certifying to that. So whenever somebody gives you a certificate and says, okay, sign off on it, there may be challenges to that because you didn't draft it. So it may call on you to assume required knowledge that is outside your knowledge or control based on the scope of services that you've provided. That is a challenge because you may be being asked to certify the things that you don't know about or have control over. And it may call for legal conclusions that you are not able to make because that's a legal conclusion that should be provided by an attorney. And from a risk standpoint, it may impose a duty and responsibility that expands those and what you have assumed by contract. And for that expansion, you may not be getting an additional payment. And so it may not make sense for you to provide that certification because it's not something you've assumed responsibility for in your scope of services, and you're not being paid to assume that risk. And then finally, it can create a potential liability to third parties, known or unknown at the time of certification. So if, for example, you're certifying that there are sufficient funds to complete the project, you may not be in a position to know that. And furthermore, if you're providing that to the financier, that could lead you to a claim from the financier if there aren't indeed enough funds to complete the project. So it really doesn't make sense for you to assume responsibilities that you are not in control of. So ideally, a certification request should be consistent with your contractual scope of services. It should be identified as to its purpose, the applicable time and date, and recipient. And it should be either limited to a statement of facts directly known to you. So it is indeed acceptable for you to say, I am a duly licensed professional in the state of, let's say, Maryland. If that is indeed the case, you can certify to that because that is a fact that is known to you that can be verified. Or you can qualify it as a professional opinion. Based on the services that I have provided, it is my opinion that this facility meets the requirements as stated in this code section. That is qualified as a professional opinion based on the services that you've provided. That is certainly an acceptable way of handling it. That's the way you should think about any time you're being asked to provide a certification by the client. And always feel free to amend the forms that have been provided to you and make sure that it makes sense and that you're comfortable with providing that type of certification. For you to do payment applications, one thing that you need from the contractor to make this a meaningful exercise is to get the schedule of values. That is typically required of the contractor and establishes a part of the contract sum associated with various parts of the work. So if you are certifying the pay apps that are being developed by the contractor, you kind of need to know what the various parts are supposed to cost. so that based on the percent complete, you can say, okay, well, this wall is 50% done. We can pay 50% of this schedule. So if you have that, it's developed by the contractor, the owner accepts it, it helps you calculate and approve payments to the contractor based on the percentage of work that has been completed. So always use that whenever you're being asked to do recommendations or certifications for payment. So how that works is they submit a pay app, and you make a recommendation or certification to the owner based on the schedule of values. Usually, it's not your job to confirm payment by the contractor to subcontractors and suppliers, right? Because that is on the contractor to do that and make sure that they're getting the appropriate lien releases and waivers from all of their subs as they're paying the suppliers. Those are the types of things that you need to be aware of. You could be held liable for certifications to parties other than the client. So if you're providing certification statements to the lender, for example, and that turns out not to be true, even though you don't have a contractual relationship with the lender may still come after you. So be aware of certifying about payment or what is reasonable, what is available. That's really not part of your services. And also providing status reports regarding the percentage of work completed and the amount of money paid and retained. That's the contractor's responsibility. It's not something typically that the design professional should be involved with. One thing that you need to be aware of is like as the construction continues, and this is really not related to payment recommendations, is a responsibility for record drawing. The owner may want to have a copy of what the installed construction looks like. Oftentimes, you may have that responsibility. What you don't want to be responsible for is to call them as-built drawings. So typically, the recommendation is that you call them record drawings so that it is clear that you are providing this information to the owner based on information records that have been provided to you by the contractor as to the location of pipes, walls, and so on, and not necessarily that you're not certifying that is the actual location, but they are drawings that you've been provided to the owner as record drawings so that they have a set that reflects where you think the construction occurred. So generally speaking, that is what you need to be thinking about for your construction phase responsibilities. For design firms especially, as long as you have budgeted your time commitments accordingly and you're being paid for it, I think the construction phase, depending on your temperament, certainly could be very interesting, and you could learn a lot about how construction occurs, what the challenges are for the constructor, and ultimately it, I think, helps make the design professionals more connected to what the construction challenges are. So to that end, this is indeed a very challenging time for the owner and the contractor, but your role is important, and as long as you help establish appropriate owner and contractor expectations, and typically that should happen at the beginning, that helps the project move along smoothly. So when you're responding to RFIs, require that they be specific and that they actually read the documents and take ownership of the contract documents. Know the requirements of the contract documents, and that is on you, the design firm that has prepared these contract documents. Make sure that your services in the professional services agreement mirror your responsibilities as written in the general conditions of the contract for construction so that it is very clear both in the owner's contract with you and the owner's contract with the contractor what your responsibilities are. If you happen to be using AIA or EJCDC documents, that is, and they're coordinated, that has been taken care of for you. But if you're using form documents, documents that are specific to the owner, you need to make sure that those are consistent. Act affirmatively in fulfilling your responsibilities and make sure that you're using qualified staff to perform CA services. Submittal reviews are something that should be looked at by qualified staff, and you certainly don't want to be assigning those types of responsibilities to folks who may not be quite up to speed on what to look for. Document your performance systematically, contemporaneously, and objectively. And if something happens that you think needs to be addressed, don't delay in asking for help when you need it. Because oftentimes time is critical on a construction site. The contractor has put a workforce out there, and they have huge costs, running costs that they need to take care of as well. So there's a time, the ability to resolve issues quickly can be a critical component, and certainly it may help reduce the claims that come in. And so that's it. I really appreciate your attention. For more information, we urge you to visit our website. Here's a look at our new website. And if you've not already established an account, you should do so. Once you register, you can view claim studies, practice management information, contract language and commentary, and past webinars, and much, much more. I thank you for